Hey folks, Keith Stickley here with the Stickley Law Firm, a full-service criminal defense law firm based in Hillsdale, Michigan, but serving pretty much everywhere in the state. And today we are going to be talking about a real doozy. The 5 things that your crazy ex-girlfriend will do to get you in a lot of trouble and probably jail. We have these phone calls every single week, and I feel bad for these guys. Now, I don't want to just pretend like we're only talking about guys, by the way, but it is by and large men that are dealing with women that they should not be. Toxic, unhealthy relationships for whatever reason. Maybe they're a great person for somebody else, but they're not a good person for you. We're going to be going over the 5 ways that your crazy girlfriend or your ex is going to try and get you in trouble and perhaps even put you in jail. And we're also going to talk about what you need to do about it or how you can stay out of trouble so that you don't have to deal with that when crazy comes a-knocking. Let's sit down and dive in. Guys, now let's go ahead and jump into this exciting topic. And it's a topic that, well, it sounds kind of crazy, obviously, from the intro, but this is a common thing that happens to normal, everyday people. Now, I know in the introduction, I mentioned, guys, hey, guys, and the stereotypical, maybe, crazy girlfriend or ex or soon-to-be ex. But it's important to note, it's not just a crazy, woman going crazy on her boyfriend or her ex-husband or whatever. In today's day and age, same-sex couples, we're seeing these same phone calls. We're seeing these same clients walk in our door. And it's something that needs to be addressed, because when you're in a toxic relationship, sometimes these things go sideways and then all reason and rationality go out the door, and then somebody finds themselves, probably you or somebody you care about if you're watching this video, on the wrong end of the law, and you didn't mean to do anything wrong. So there are 5 common pitfalls that somebody's ex can use to get you in trouble, okay? Or to get their ex in trouble, if you will. And I'm going to go over the 5 most common ones that I consistently see on a week-to-week basis. And I'm going to give you little solutions for how to deal with them. Now, these solutions might seem somewhat oversimplified, but just because the solution is simple doesn't mean it's easy. I understand that, right? You inject emotions into these kind of situations, and, well, sometimes it's a recipe for a disaster. But you or whoever that you care about who's watching this do not want to get yourself into a situation where you buy into somebody's crazy, for lack of a better term, and suddenly find you or the person that you care about sitting in a jail cell, in a cage, losing bond money, having to pay contempt of court fines. You don't want to do that, all right? So let's jump in. Number 1. The number 1 thing that we get phone calls about all the time is that an ex, say girlfriend, wife, whatever, has filed a personal protection order against their significant other. See it every day. And what is a PPO and how does this thing work? Well, a personal protection order is a civil order, okay? It's not a criminal thing. It's a civil order where a person can go to the court and they can fill out an application for a personal protection order, and they can make claims to a judge that says, Judge, this person makes me feel threatened, and I'm concerned that if I am not somehow protected by a legal order that separates us, that I could potentially be harmed in some way. And a judge will read these things, what's called ex parte, meaning without the other party, and very often the judge will grant it. And if the judge grants a PPO against you, that means you cannot have contact with this person. You can't do it. So what is the solution? The solution is you have to protest the PPO. 14 days, you have to retain counsel and protest it, or go to the courthouse and get the paperwork to protest it, to modify or terminate the PPO. If you do not try and do this within that allotted time, the PPO will stand and you are blocked from having any sort of contact with this person for a year. And it can also interfere with your hunting rights, your Second Amendment rights, a bunch of stuff. You get put in the law enforcement information network. It makes you a big target. Makes you a target just driving around. It's amazing how many clients we have that have gotten like a PPO put against them, and suddenly they're complaining about getting pulled over under suspicious circumstances where nothing was wrong. Law enforcement can tell. So that's the number one way, okay, that they can get you in trouble. They can file a PPO on you. Let's talk about the solution. A little recap. The solution is you can protest that personal protection order by filing a protest against it within 14 days. You can do this yourself. I recommend highly that you get qualified counsel who deals with this quite often, as we do, because we know what the legal standards are and the arguments are. So many, and this is really sad, so many people are using the PPO process in Michigan as legal warfare to get an edge in something and just to mess with people. And they're filing these bogus PPOs, and you better get an attorney who can spot the nonsense, knows how to question people on the stand when you have your modification or termination hearing, and will really make them prove that there is in fact enough grounds to have a valid PPO. So that's what you got to do. You got to fight it, right? You got to fight it within the time frame. And the number two way is for the person that filed to get the PPO, they will invite you over to try to make amends or have a conversation about the relationship after you've already been served with the PPO. So let's say your name's Henry, and Henry, you got served by your ex-girlfriend Sarah with a PPO. She tells the court, "Oh, I'm so afraid of Henry. Henry's a terrible guy. He does this, that, and the other." And the judge signs off on it, and Henry, you didn't hire an attorney or you didn't go to court within the 14 days, and the PPO stuck. A couple of weeks go by. Sarah is suddenly very lonely because Sarah misses you, and Sarah misses you taking her out for dinner and buying her things and paying the bills and whatever you guys do, right? She misses that. So it's a cold, lonely night, and Sarah calls Henry up on the phone. Bring, Henry, I'm sorry. I know we shouldn't be talking or whatever, but I'm going to drop this PPO. This thing's crazy, and I acted out of sorts and whatever. And then Henry's sitting there going, it's been a long time since I had me some Sarah. I need to go over there. No, Henry, you don't need to go over there. The only person, I'm going to repeat it one more time. The only person that can drop the PPO is the judge in the courthouse. She can't. And PPOs are a one-way street. If Sarah has a PPO against Henry, believe it or not, there's no legal prohibition on Sarah contacting and trying to sort of reseduce Henry. And if Henry responds to Sarah's advances and invites her over, guess who's in violation of the PPO? Henry. And if you get found in violation of the PPO, you can be held in contempt, you can get a $500 fine, you could be up in jail for 93 days, and folks, this happens. People weaponize PPOs all the time. Do not fall for this. Don't do it. I feel terrible having to take money and represent clients who find themselves in this position, because 9.5 times out of 10, they're good guys that have never had any contact with the criminal justice system, right? And some of the worst cases are maybe there's a kid involved. Maybe it's not really Henry's kid, but Henry has fulfilled that father role. He's been taking care of the kid. He misses the kid. Sarah will use the kid. Little Johnny misses you, Henry. You can come over just to see, little Johnny, and Henry does, and there you go. It does not matter if she seems friendly. Don't do it. Don't do it. What is the solution to that? If she genuinely reaches out and says she doesn't want the PPO, and you pick up the phone and you don't expect it to be her, but it is her, two things better happen. Number one, you better say, I have a PPO. You're protected by a PPO. I cannot talk to you. Click. The next thing you do is you hire your attorney or whatever, and you find out a way to get information through her, not through a third party. You really can't do it. But if you hire an attorney and she's a witness, an attorney could, to say, hey, look, if you really want the PPO dropped, Sarah can fill out the paperwork, send it to the court, and the court will consider Sarah's paperwork and consider dropping the PPO. You do not violate the PPO until the judge tells you to. I don't know how many times I need to say it. I say it till I'm blue in the face, but every single week we get clients that do it. So that's number 2. Number 3, the number 3 most common way in a bad relationship, she is going to get you in trouble and potentially going to jail. False or exaggerated domestic violence claims. This part truly makes me angry because there is no doubt many victims of domestic violence in America, in Michigan. And I am in absolutely no way excusing that or saying that all domestic violence claims are bogus, because they're not. There are real victims of domestic violence that has been perpetrated by bad actors, bad dudes, who do not deserve the women, or vice versa, quite frankly, or women who do not deserve the men who have been in their life and supposedly purport to love and care about them. But that's not what I'm talking about. That's not what I'm talking about. What I'm talking about here is a former significant other making grandiose, exaggerated domestic violence claims to get the other person in trouble. And you know what? I hate to say it, but it happens time and time and time again. I see this all the time. I read these police reports and I'm like, really? You consider this domestic violence? And sometimes I have to take these to a trial. And I'll put the alleged victim on the stand. And if the story doesn't add up, the story doesn't add up. And unfortunately, that's not uncommon. People will weaponize the domestic violence process for their own leverage. There are a lot of dirtbag divorce attorneys who will counsel their clients in how to strategically make some sort of claim, domestic violence-based claim, to try to gain leverage out of a divorce or out of custody battles with kids. And sadly, that's common, and that makes me sick. And when I'm able to help people who are charged with domestic violence crimes, who truly are sort of in that cycle, I do it with pride, because that's nonsense. And what it really does, quite frankly, is it takes the believability, the credibility away from true victims of domestic violence who need to be heard, who need to be supported, and who, of no fault of their own, have become victims, and it lessens their credibility. So I don't like that at all. But what can happen if you're charged with domestic violence? Well, you are oftentimes, almost always, you are given what's called a no contact order, okay? A no contact order. And we'll get to that in number 4. But the exaggerated domestic violence claim is the third most common. Now, what do? You lawyer up. You lawyer up. If you can't afford a lawyer, work with your public defender if you qualify. But make sure you go over all the juicy details with your attorney so that you have the best possible chance at defending yourself. By the way, in Michigan, domestic violence as a first or a second offense is a misdemeanor. So you're going to want to look at our channel. Go ahead and click like and subscribe to the Stickley Law Firm channel that you're watching this video on. We actually made a video on the anatomy, the full process of a misdemeanor case. If you find yourself being charged with domestic violence first or second, you're going to want to watch the how a misdemeanor works in the state of Michigan video. If you're charged with domestic violence as a third offense, that will be a felony. We have a felony video, like how a felony case really works in Michigan. You're going to want to watch that on our channel as well, so you understand how a felony case works. So lawyer up, fight the case, give good information to your attorney, get those proofs going, and hopefully you'll be all right. But let's talk about number 4, the fourth common way a ex or significant other person that you don't need to be around anymore will try and get you in trouble and potentially get you into jail, and how you can avoid or fix this situation. And that is breaking a no contact order from a judge. If you are charged with domestic violence, the judge is going to put a no contact order between you and the person who is accusing you of the crime. A no contact order means just that. You cannot have any contact in any way, shape, or form with this person until the case is done or the judge formally lifts the no contact order. And guess what? Those dirtbag divorce attorneys that I was referring to in the last section that we were talking about, they love this. They absolutely love this. Because when a guy gets charged with domestic violence and a no contact order is put in place, and suddenly the sympathetic supposed victim is calling him saying, hey, I need you to pick up the kids. Hey, it really wasn't that bad. I'm sorry I talked to the cops when I was mad and whatever. Suddenly all those emotions start going in, and kids are often used as pawns in these situations. And suddenly you're thinking, oh, wait a minute. I really miss my ex, and she's going to bring me back into the home, and I'm sick and tired of sleeping on my buddy's couch, or it's hard to afford this motel room because I can't live with her because we have this no contact order. And the next thing you know, you break down and you go over to her house. I hear this time and time and time again. You can't do it. If you break the no contact order, the judge almost always, at the very, very least, is going to hold you in contempt, and you're going to be sitting in jail for a couple of days. And you could even have new additional criminal charges that don't even depend on an alleged victim changing their mind or not testifying. So do not, I don't care how much she wants you to come over. I don't care how much she wants to make amends. Until the judge says you can talk, do not talk. That's the solution. That's how you don't get in trouble. That's how you don't fall for this. Don't fall for this. I'm saying don't fall for this so many times. Yet, in the next month, I'll have 5 guys walk in my door. Good, law-abiding guys who are just in a toxic relationship if something's gone south. And this is the situation that they'll be in. And we'll do our best, and we fight. We get a lot of these dismissed, but it's at great expense. It's at great time. It's at great stress. When you got the no contact order and she says, I'm dropping it, or it's okay if you talk to me, it's not okay. Don't do it. All right. That's number 4. This 5th one, I'm going to freely admit, it's a little different than the first 4. If you fail to pay your child support, your court order, the judge can hold you in contempt. Once the amount that you owe reaches a certain amount, they issue you a warrant for your arrest, and you get brought in front of the judge, and they want to know why you haven't paid, and here's the arrearage, and it's a whole mess, right? And there's not a lot of defense. There's not a lot. I don't care what any lawyer trying to pitch their services tells you. You either paid or you didn't. And there's not a whole heck of a lot of wiggle room, especially if the state attorney general gets involved. And if you're going through this and you know what, in the state attorney general's involved, you know what I'm talking about. And if you don't know what I'm talking about, maybe we'll make a video on it in the future, but you don't want to know what I'm talking about. So how do we avoid this? We pay our child support. But we don't just pay our child support. What happens when real things come up and we can't pay our child support, right? The number one thing I see time and time again is that people don't keep up proper records with the friend of the court. And I know it's a pain. There is an office in almost every county in the state of Michigan called the friend of the court, and they're usually responsible for coordinating the child support, the benefits, taking the money, dispersing the money, that kind of thing. And sometimes I see these warrants, these guys come to us for help, and I'm like, wait a minute, how much money do you make? And they're like, I make $50,000 or whatever, and I've got 2 other kids, but I get stuck with this child support bill, and it's $1,000 a month or some crazy amount, right? And I ask them, well, when's the last time you communicated with the friend of the court and tried to get some sort of a child support reevaluation or recalculation, and they look at me like I've got two heads. I never heard of that. Or even worse, they lose their job. They go through a period, maybe they're paying child support because they're trying to do the right thing, and they lose their job, and then they don't tell friend of the court that there's been a change in what they can pay. And then the next thing you know, the arrearages keep building up and building up and building up, and then they're charging penalties and fees, and the whole thing gets overwhelming. And again, these are good guys that are, you can't squeeze blood from a turnip. If you lose your job until you get another one, you kind of got problems, right? You got to communicate with a friend of the court. Time and time and time and time again, we've had clients where if we can keep the communication train going, the honest communication train going, right? We don't make excuses. We say, hey, look, we're in some problems right now, but we're going to get back on the job horse. We got some things going. Just communicating like that, openly and honestly, can make a massive difference in whether or not when you get picked up on a child support warrant, if you actually have to go to jail and you're held in contempt, or if you kind of get a talking to and the judge sends you back out to get your job, to get the money flowing back again so you can get caught up and on your feet. The only thing that society really wants is they want their kids taken care of. And if you're a mom who's ordered to pay child support or a dad that's ordered to pay child support, you created kids, you got to pay for those kids. That's what it is, right? And the vast majority of people, yeah, there's nasty deadbeats out there, but the vast majority of people don't want to be a nasty deadbeat, right? So that's the number 5th way. And I can tell you this, if you're trying to avoid being, serviced, as far as, somebody's trying to give you papers because you're being sued for child support or whatever, that just makes the situation way worse. So to help correct that situation, take the papers, call the people, communicate openly, be honest about what your income is, and that's how you deal with it. That is the 5th most common way that an ex will get you in trouble, and that's how you have to deal with it. You deal with it by honest, upfront communication, paying what you can. When you can't pay, you communicate why, and you got to keep the ball rolling. So that's how this whole thing works. So if you found this content entertaining, enlightening, and educational, do us a big favor, like our video, subscribe to our channel, and most of all, if you or somebody that you care about find yourself on the wrong side of the law, give my office here at the Stickley Law Firm a call, all right? We'll sit down, we'll bring you in, we'll have an in-depth conversation, we'll analyze your case, we'll go over any defenses, we'll take a really strategic look at what we might be dealing with and how we can help you. Until then, stay safe, and we'll talk to you real soon.